Okay, my name is Jed McKeehan, and today we're going to talk about the discovery process. I've talked in previous videos about the complaint and the answer, and when you file those, what those mean. Well, what happens after an answer is filed? Well, usually the trial for the case gets set a few months out, and during that time period, Tennessee law allows for discovery. And what that means is it gives the attorneys and the parties an opportunity to find out things about what the person they are suing or the person suing them is going to say, or what their position is in regard to the case. And that way they can evaluate whether to settle the case, what to expect at trial, and things of those nature. And discovery takes place in generally two different ways. The first is written discovery, and that is called interrogatories and request for production of documents. And that's a document that you send to the other side, and that you ask them basic questions about the case or request documentation. You can ask them where their injuries occurred, if it was in a car wreck, or what kind of medical expenses they have, and documentation of the medical records and things of that nature. And they are required to give you that information in regard to the claim. And that way you can evaluate what you are facing at trial. The second main way that discovery takes place is in depositions. And deposition is one of those words that if you're not familiar with the legal system, you may have heard, but you're not exactly sure what it means. Deposition takes place in a conference room at a lawyer's office, and one attorney is present with his client, and the other attorney is present with his client. There's also a court reporter there who swears everyone in and tells them to tell the truth, the whole truth, and nothing but the truth, and then they write down what is said at that deposition. So it's got some formality to it, and you're supposed to tell the truth, and again, it's so the parties can evaluate what to do with the claim. And the attorney from one side will ask the other party all kinds of questions. And under Tennessee law, they're allowed to ask them pretty much anything in order to find out about the claim. And they can ask them questions about if it's a slip and fall case at a business, whether people had previously slipped before, whether the surface of the floor was usually slippery, if they were supposed to put out caution signs, things like that. That can better help them evaluate where to go and what the other party is going to say. So to recap quickly, in the discovery process you have two main things: the written discovery, which is the interrogatory and request for production of documents, and the depositions. In our next video we'll be talking about what happens after that discovery process.